very good evening and a warm welcome to another episode of Law and Order. And just a few weeks ago, we celebrated the 71st anniversary of the Universal Declaration of Human Rights. And along with the concept of human rights, what we talk about in Sri Lanka is the concept of fundamental rights. So we have a very special guest with us on Law and Order today to discuss about the law behind fundamental rights and the remedies a person, a citizen of Sri Lanka can get when his rights are violated in Sri Lanka. And we are happy to welcome to our studio at Channel I, Mr. Rajiv Amarasuriya, attorney at law. And it's a great honor to have you here, sir.
It's nice to be here again, Shahada.
And so, sir, I'll just ask you to set out the two concepts separately. We always talk about the concept of human rights. And in Sri Lanka, we can legally enforce only fundamental rights. What is the difference between the two?
Yes, Shahara. Human rights are those rights we as humans are entitled to. We are born as a human, you have certain rights, the right to live, the right to clean air, right to education, right to health, so on and so forth. Much of these rights were actually listed out in the Universal Declaration of Human Rights, as you know, you mentioned it so many years thereafter in 1948. So basically human rights is basically all those types of rights which you and I would think we are entitled to. Fundamental rights are those rights from and out of the human rights which have been taken out and which have been given legal force through a constitution of a country or some legal document. So since we are looking at it from our Sri Lankan point of view, fundamental rights in Sri Lankan context are those rights which have been captured within our constitution and which have been given the status of fundamental rights.
And also, when we talk about fundamental rights in Sri Lanka, it's guaranteed by the constitution.
Yes. And
the constitutional fundamental rights only guarantees action against state parties.
Yes, that is so. Articles 126 and Article 17 of the Constitution provides, this is how it works. One is the right, the fundamental right, then the enforcement mechanism. Now, the Constitution lists out several fundamental rights and provides that all persons are entitled to those fundamental rights, and also goes on to say that all public institutions, government, basically the government machinery, is responsible to or should further those rights. Now, so that on one side, those are the rights. Then you have the enforcement mechanism. So, enforcement mechanism provides that if you have a grievance that one of your fundamental rights have been violated by executive or administrative action, then you have recourse to the Supreme Court. Now, you will ask me what is executive and administrative action. In layperson's terms, executive and administrative action means basically action which has been or something which has been done by, again I used the word government machinery or the state, or by a person or institution under the color of office of the state. So basically it is against state government action. When I say state, it does not mean I am not referring to the politicians. I am saying the whole machinery, whether it's the Grama Niladhari who you have in the village, or whether it's your the local authority, or whether it's some government department, whether it's possibly a corporation in some instances. So likewise, any violation by any state entity, then you have recourse to the Supreme Court.
And also, sir, when we talk about fundamental rights, we have a limited list in the Constitution. Yes. Would you be able to elaborate on what are we actually entitled to?
Yes. Now, it sets out certain rights, the freedom of thought, conscience and religion, that is that you are entitled to have your own belief, your freedom of thought. You can follow any religion of your choice. Then freedom from arbitrary arrest, torture, cruel and inhuman and degrading treatment. Say for example, you are arrested, it must be in terms of the law. You can't be tortured to maybe get illicit evidence. Cruel and inhuman degrading treatment. There are instances where sometimes children have complained that they have been, maybe assaulted or hit or whatever, slapped in school, and then that amounts to cruel treatment. Then you have the right or the right to equality and equal protection of the law. Basically, that all citizens are entitled to the equal protection of the law and also equality. That is from discrimination. So, state entities, state action cannot discriminate you against others. Of course, they work in certain classifications. Then we have the freedom of, then we have a whole list of other rights, the freedom of movement, freedom of occupation, freedom to have your own profession, freedom to live in any part of the country, freedom to say join a trade union, form a trade union, likewise. And to the 19th Amendment, the new right, the right to information was brought in, Article 14A. So basically, in simple terms, those are the rights which one is entitled to in terms of the Constitution.
And so now, in the event, if we take the practical aspect of Sri Lanka, with your wealth of knowledge and experience in being in practice for many years, do you feel that the mechanism or the people actually use fundamental rights effectively to enforce their rights against the state, or the use of fundamental rights is actually not that not that common in Sri Lankan society?
No, it is made use of. Those who are affected, I mean, often, you go to a lawyer and you say, what can I do? And the lawyer will advise you, well, there's maybe a possible violation of your fundamental rights, and you go before the Supreme Court. So, and we have a large number of cases filed on a yearly basis before the Supreme Court. So certainly there is awareness, and those who are aggrieved, affected, do actually go before the court. Then also there are instances where, for example, you might ask a question, well, I'm destitute, there's a violation, what do? I can't afford a lawyer. But there are instances where you can even, not all the time, but if you're in such a situation where you're not able to, go before the court, maybe you're incarcerated, maybe you have no access to a lawyer, then you can even, there are instances where even the Supreme Court have accepted even a letter from a person saying, well, this is a violation of my right, and then you take it upon, the court takes it upon, and then maybe refers it to the Legal Aid Commission. That is because the Supreme Court Shahada, in the fundamental jurisdiction, exercises what we say just and equitable jurisdiction. Now, the only other tribunal in the country which exercises this is the Labour Tribunal. So when you say just and equitable, it's not purely in terms of the law. If you go, say, for example, say a civil action in the district court, one would relate it to the law, and you are within that legal confine. Here, the Supreme Court, when you go before, it's not necessarily the legal framework itself. There will be a balancing of rights, the affectation to the citizen, the benefit to the state. Likewise, the discussion is much wider.
And in the event an individual, let's say for an example, one of our viewers has faced a violation of his fundamental rights by an executive or administrative action, what remedies are available for him? What can be done regarding it? Is it only compensation, or is the Supreme Court the sole remedy a person has when it comes to enforcing fundamental rights? And what other platforms are there by law to guarantee this right?
There are a couple of questions in that. Firstly, if you look at the relief, we'll look at it in sequence. Let us look at the options you have. In terms of the Constitution, one can go before the Supreme Court. You have to go within a period of one month from the infringement or imminent infringement. Infringement means if something happens to you, a decision is made, an order is made which violates your fundamental rights, then within 1 month of that date, you need to go to the Supreme Court. Then also imminent infringement. Say, for example, today I know that something is going to happen to me in a week's time, or some decision is in the pipeline, and in all certainty it's going to happen. And so I'm aware. So I can go even now. I don't need to wait for that 1 week or 2 weeks till that decision takes place. So one option is the Supreme Court. Then there are certain other avenues. Now, for example, the Human Rights Commission. The Human Rights Commission also has its jurisdiction to go into violations of fundamental rights. It's set up by a piece of legislation. and they investigate into matters. It's not a court process, so it's easier to institute, easier to go before, and you don't need to be represented by a lawyer also. The only drawback in the Human Rights Commission is that it is not a decision as such. It is not a binding decision which is made by the Human Rights Commission. The Human Rights Commission, in terms of the law, is empowered to make a recommendation. Well, I think that's one area which we need to look at, because the Supreme Court also is inundated with hundreds of fundamental rights applications, which actually results in a backlog of cases. So we need to, I think, look at, moving forward, giving more teeth to the Human Rights Commission. But for the time being, so it is a recommendation which they can make. But having said that, there are a number of circulars which have been issued by the state over the years, over maybe 10, 15, 20 years since the formation of the Human Rights Commission, directing state authorities to implement recommendations by the Human Rights Commission. And often it is those recommendations are in fact implemented, but I have come across there are instances when they do not, and then you are compelled to go back to court, maybe to enforce those decisions or seek some judicial intervention. So that is one second option. Then you have the Parliamentary Commissioner of Administration, that's Ombudsman. That works within the sphere of the Public Petitions Committee of Parliament, and that also in relation to grievances within the structure of, say, public authorities, corporations. It's more to do with officers in those institutions, and one can, or of course, if there's a violation, even a citizen. So in that instance, you have to go before the Ombudsman. But again, in that situation, it's a recommendation. So both the Human Rights Commission and the Ombudsman, if there is non-compliance, what can be done is that either the HRC or the Ombudsman then can refer it to the President. But it's not as efficacious as the Supreme Court, because the Supreme Court is the final apex authority, and when Supreme Court makes an order, then of course one has to implement or follow that order, or there is contempt of court. The last bit of your question was what remedy one has before the Supreme Court. In Supreme Court, I said it's just an equitable relief or jurisdiction. So one can ask for one is of course restitution, remedying the act, setting aside the act, and also you can seek compensation. So the Supreme Court on several occasions has granted compensation. So you can remedy whatever the loss or damage or prejudice caused to you.
And so I think the court procedure is rather familiar to our viewers and also to many in the general public. But is there a special procedure to be followed when filing action at the Human Rights Commission?
No. Well, the Human Rights Commission, there is a application form. Basically, it requires filling up certain information. The cause of action, we call it in lawyers' terms, but the grievance, the parties, the persons who have perpetrated, or persons we allege who has perpetrated the acts, those who we might call in evidence, and some other details about your circumstances and the documents you want to submit. So it's not a difficult application to fill. So even without assistance of a lawyer, one can fill the form.
And also regarding the ombudsman and its...
So it's again an application like that. I am not too sure there's a form, but I think you can, in the form, an appeal. So it's not difficult.
And also, sir, now when there has been a criticism about fundamental rights, firstly, regarding the time period of 1 month. Now, this has been severely criticized by many activists and also people who call for law reform regarding fundamental rights law in Sri Lanka, because a lot of people allege that 1 month's time period is not sufficient for a person who is aggrieved to even make a decision on whether he should litigate or not.
Yeah.
And secondly, just another additional question which is related, there has been also another criticism that fundamental rights jurisdiction is actually limited to only the state mechanism. If one's fundamental rights are violated by a private authority, a private firm, for an example, or if the right to equality is violated at a private company, then you would be left with no remedy at all. What is your response to those two criticisms when it comes to fundamental rights?
These are difficult questions. As a practitioner, I might looking at it purely as a practitioner, I will probably agree with you and say, well, you need to widen the jurisdiction because but the time period is actually a little difficult. Something you have to file cases within a month, and you have to those aggrieved might not be in a position to do so in a month, and it is good to expand the time limit. And there are jurisdictions where you don't have a time limit. You can go on any date or in any time when you're able to. But the flip side of this is that for now we are now in the present fundamental rights jurisdiction, one is challenging state action. Now the presumption is that official acts or state acts would be done the right way, would be done in the interest of the public, interest of the citizen. So one cannot presume that those acts are done to discriminate or violate someone's rights. Now the problem is, if you give a longer period of time, if you look at it from the other side, then there is uncertainty in those decisions. For example, say some authority makes some decision, good or bad, decision is made. Now if you say, well, you have 1 year to challenge this, then the authority also has to wait for 1 year to see whether this is challenged before actually, or you can start implementing it, but you will be in two minds. You will not know whether at some point there will be a challenge. So, and a country like Sri Lanka, where we are really, we need quick development, we need to fast track whatever we have, and we need to go to the next level. At this juncture, I don't think widening this widening. I mean, I'm talking not as a practitioner, as a lawyer, but I mean, if you look at both sides of the divide, I think what we have is probably adequate, because if you give more than that, then there's uncertainty, and also it will be difficult for the state to function in such a realm. Then, in response to your second question, which is whether this could be widened to cover other institutions, well, I think in the long term it would be good if one could say, for example, you have been discriminated on some racial basis, for example, by some establishment. What do you do? The fundamental rights jurisdiction, the Supreme Court, you can't go and say there is not executive administrative action. There may be some civil remedy one can look at, but it will be complicated. So maybe those things are things which we must look at going forward. And of course, you can't open the gates to cover each and every situation, but maybe in limited instances widen it so that it's a deterrent, and it prevents that type of discrimination. But those are issues which one needs to balance the rights and interests and see what can be worked out.
And also, sir, when we talk about issues of fundamental rights, these rights some of the rights are not absolute, in the sense they are restricted by the government to a certain extent, yes, by law to a certain extent. Would you be able to elaborate on what these restrictions are and to which extent these restrictions are?
Each of these rights can be restricted in certain circumstances. I'll just take a few examples. Now, I said you have the freedom of freedom to choose your freedom of trade, business, profession or vocation. But the state is entitled in terms of the constitution to have certain restrictions. Now, for example, you have you have your Sunday market and you have to sell some goods. In terms of the restrictions, the state or whatever the authority can say, well, you have to obtain a permit. Just because you have a freedom, that is within a certain framework. You need to obtain a permit, pay whatever the amount they charge, and then you sell your product. Now, for example, if you want to practice as a lawyer, you need to you have to become an attorney at law. Likewise, so then there are other situations where, for example, national security, freedom of movement, you can live anywhere in the country, but maybe those can be restricted in terms of national security. Also, also in the interest of the economy. For example, maybe the state might demarcate a certain area, saying that is for economic purposes, that is for commercial purposes, not for residential. So you can restrict those rights. So it needs to be in place. So there are several restrictions like that, which can be brought within, which can restrict the fundamental rights.
Now, sir, my final question to you before we wind up today's segment. Now, it's been said that the 19th Amendment to the Constitution further strengthened the position of fundamental rights in Sri Lanka. What changes did it make to the fundamental rights chapter?
Well, of course, there is a new right, the right to information. So that is important, right? Because as citizens, you are entitled to have access to any documentation, and also the regime provides that the right to information regime. You don't need to provide a reason. So I can just write a letter and say, well, I need this information. So provided it falls within the information which can be disclosed, one is entitled to that information as of right. Then, of course, I think the re-establishment of the independent commissions was an important measure which was taken, because it placed certain workings or certain roles of the government within a different sphere, which is now an independent process. So to that extent, I think it strengthens the strengthening of democratic institutions. So likewise, there were some changes like that which were brought in. So I think overall, well, to that extent, not take the Elections Commission. Now that is an independent commission now, and I don't think anyone had any complaint about the conduct of the election. So otherwise, there could have been allegations that there were violations of fundamental rights if it was not conducted properly. So I think overall there was a lot of good progress to the 19th Amendment.
All right, sir. So with that, we would like to conclude today's episode on Law and Order, which where we discussed the issues of fundamental rights and the legal background behind it. So on behalf of Channel I and its administration, I would like to thank Mr. Rajiv Amarsurya for taking time off and for joining us today for today's program, sir. It's a pleasure to have you at Rupavahini.
Yes, thanks, Shara. My pleasure too to be here.
And with another episode of Law and Order, bringing you knowledge and practical aspects of law, we would like to meet you again, where we, as Sri Lanka Rupavahini Corporation and Channel I, we wish to enlighten the society on different aspects of law, different aspects of the practice of law, and to create a society where people are actually knowledgeable about the law and who knows and who can actually enforce their rights in a legal court. So with that, we conclude for today. We wish you a good night.